again, for that first element, now, if you can make a good faith claim of disability, you're probably going to be disabled for purposes of litigation. Not always. You still have to go through the steps. You still have to establish major life activity and how your physical or mental impairment substantially limits that. Nevertheless, courts are willing to grant much broader deference to a claim of disability. Instead, the focus now is on the interactive process. The second element of the prima facie case, he or she is otherwise qualified for the position. Now, how do we know what is otherwise qualified? Well, we look to see, can the individual perform the essential functions of the job with or without accommodation? So an employer cannot terminate or refuse to hire an employee who is otherwise qualified. The employer must determine the essential elements of each position within the firm. And this is one of the responsibilities you'll have as a manager when you get out into the workplace. All of your positions, you must know what the essential elements of those positions are. The reason being that is if someone can meet those essential functions with or without accommodation, then they are otherwise qualified for the job. For instance, in many law firms, there's a receptionist. And the receptionist's real job is to handle incoming phone calls, to meet with clients who come in to visit with their attorneys, to route faxes around to the various employees. But oftentimes, the receptionist is also required to serve coffee to the client when they come in, to offer coffee, to clean up around the place, to do Christmas decorations at Christmas time. Well, those functions, cleaning up, serving coffee, putting up Christmas decorations, are not the essential functions of the position of receptionist. And therefore, when looking to determine whether someone's qualified to be the receptionist, you cannot regard those other non-essential functions of the job. There are some things that an employer cannot consider. You cannot consider those non-essential functions in determining whether a person is otherwise qualified for the position. Now, the ADAAA, again, prohibits the use of a test to determine otherwise qualified based on uncorrected disability. So it's the opposite of what we were talking about. You have to take into account in determining disability the non-mitigated effects. Well, in terms of otherwise qualified, you have to accept the corrected disability. The corrected disability, the ability to do the job, having it mitigated. What are essential functions? The acts, both the ADAAA and the ADAAA, require determination of essential functions. And the term of essential refers to those tasks which are fundamental to the job. You cannot include in your job description things that are incidental or tangential responsibilities to the position. Only the essential functions of the job. In this case, Pickens versus Sioux Line Railroad Company, the question was, is attendance an essential function of the job? Mr. Pickens was a railroad engineer. He was a conductor. He worked on a train. Mr. Pickens had a back problem, and for much of the year, Mr. Pickens was able to do his job without the need for any special accommodations. Occasionally, however, his back would go out and he would be unable to come to work. Now, the railroad company had a number of days, both personal days and sick days, available to Mr. Pickens, and those added up to 20 days throughout the year in which Mr. Pickens could miss work without the need for an excuse. But in one particularly bad year, Mr. Pickens was suffering from back problems more than usual, and therefore quickly ran through his 20 available off days and sought an accommodation. I can't work because of my back, therefore you have to keep me employed until I can work again. And what Suline said was an essential function of the job is being on the job, attendance. And in this case, the railroad company won because they were able to establish that in order to do the job, you had to be physically present at the job. The third element, the disability can be reasonably accommodated. Now, reasonable accommodation generally means the removal of unnecessary restrictions or barriers, whether those are physical barriers or physical restrictions or simply part of the workflow issues. That reasonable accommodation is that accommodation which doesn't place an undue burden or hardship on the employer. Just as with religious discrimination, religious accommodation, reasonable accommodation, permissible up to the limit of undue burden or hardship. What do we mean by undue burden or hardship? Again, it's not limited to financial difficulties, costs, although that certainly plays a role. Some examples of undue hardship are not acceptable defenses to a claim of discrimination if, in fact, it's not an undue hardship. And how do we determine? We look at the nature of the employer. We look at the nature of the accommodation sought. We look to determine whether this is something that is necessary or not, whether someone else could assist or not. If you have a person who, say their job is unloading trucks and they injure themselves and need to be on light duty, they can work, they simply can't load and unload trucks. If you're in a large organization in which someone else can do the truck loading while the person on light duty works the front desk or handles administrative affairs, then it's not an undue hardship even though you hire that person to unload trucks. In this case, Cassidy versus Detroit Edison Company, Mr. Cassidy developed what he called environmental illness. And this was kind of a thing back in the 90s in which many people claimed to be allergic to the world. And Mr. Cassidy worked for Detroit Edison, and he asked for an accommodation. And his accommodation was essentially that the company would build him his own personal clean room to prevent any contamination. So he would have his own private area. There would be a separate air management, air purifier system there. No one could enter or exit that area without going through a decontamination process. And in this case, the court said that's too much. That is an undue hardship. Despite the fact that Detroit Edison is a very large, profitable company, we can't expect them to create this clean room environment for just one employee. Again, the focus is on the interactive process. Are the parties attempting to work it out themselves? Finally, he or she suffered an adverse employment decision. Just as with all the other areas of Title VII, this is construed broadly: hiring, firing, promotion, demotion, benefits, loss of benefits, access to training, loss of access to training. Any of those could qualify as an adverse employment decision. Finally, the ADAAA has changed the analysis of a disability discrimination case. What we've seen in the last few years, despite the law essentially remaining the same, we have seen that disability discrimination claims no longer focus as intently on whether the employee is disabled. This was the major sticking point for disability claims. Were they disabled? Were they a member of the protected class? Now, the prima facie case is not meant to be a huge thing to overcome. In the other types of discrimination, it's pretty simple. to prove a prima facie case. So what the ADAAA did in terms of broadening the definition of disability was really to make the prima facie case easier to prove, which then shifts the burden over on the employer to engage in this interactive accommodation process. And nowadays, rather than focusing on is this employee disabled according to the law, courts tend to focus on whether the employer properly engaged in the interactive process. Did the employer attempt to accommodate the disability or not? And finally, was a reasonable accommodation provided? And if not, why not? So these are the things that we've seen develop as a result of the ADAAA. So in conclusion, what did we learn today? Disability discrimination regulation has a long history. There are requirements to prove the case for disability discrimination. We went through each of those, and employers have a number of considerations in regard to disability discrimination. And that's all. Thanks for listening.